1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်826 ဦးထွန်းမင်း and 1 appellant versus People's Bank number 22 Rangoon respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးသက်ဖေ Judge ဦးထွန်းမင်း and 1 appellant versus People's Bank number 22 Rangoon respondent sued for declaration that the transfer of a house was void against the creditors, presumption of fraud in case of a voluntary settlement transferor largely indebted at the time of settlement transferee to show good faith as well as payment of consideration, whether a gratuitous consideration such as natural love and affection is a valuable consideration, sued by the respondent bank for a declaration that the transfer of a house made in favor of the first appellant by his father, who was a judgment debtor of the bank, was void against them and other creditors. Hell, there is a strong presumption of fraud in case of voluntary settlement when a transferor is largely indebted at the time of the settlement. This presumption will be further strengthened if the transferor conveys all his properties without making any provision for his creditor. Mountain Singh versus Upo Nyo, AIR 1933, Rangoon, page 252, at 253, refer to and follow. In order to save the conveyance from the liability of being avoided, it must be shown that a transferee had obtained the conveyance in good faith as well as for payment of consideration. A gratuitous consideration such as natural love and affection is not a valuable consideration. A transfer in consideration of natural love and affection is not a transfer for consideration. Chidambaran Chadiya versus Srinivasa, Such Trial and Others, AIR 1914, PC, page 137 at 139. Ramasamy Pillai versus Adinarayana Pillai, 20, Madras, page 465. Subel Gua versus Dasut and another, AIR 1919, out, page 95, refer to Usainbu for the appellants, Mr. C.C. Ko for the respondent, Uttape Judge. On 3rd March 1959, the respondent sued 1. Ubadin, the father of the first appellant, for a recovery of debt 12,707 pya in the Rangoon City Civil Code. A consent decree was passed on 8 December 1960. The respondent took out execution of the decree and attached a house known as numbered 466 Lower Bazundao Road, Rangoon. Then the first appellant applied for the removal of and succeeded in removing the attachment on the ground that he was in possession of the house after Ubadin had conveyed it to him by a deed of gift day 28 June 1960. the respondent thereupon sued the appellants and 6 others for a declaration that the transfer made in favor of the first appellant by his father Din was void against them and others creditors. The first appellant pleaded that he was unaware of the litigation between his father and the respondent and that the gift was executed in lieu of inheritance. The learned chief judge of the Rangoon City Civil Court, who had session of the case, decreed the respondent suit after hearing the parties and their witnesses. Hence, this appeal. It is well settled that there is a strong presumption of fraud in case of a voluntary settlement when a transferor is largely indebted at the time of the settlement. This presumption will be further strengthened if the transferor conveys all his properties without making any provision for his creditor. Thus, it has been held in Mountain State vs. Uponyo 1 that it is only when there are creditors in existence at the time of the graduate's transfer or when a transfer is made just before a man embarks on some very hazardous speculation that it can be presumed that the gift is made with intent to put his property out of the reach of his creditors. In the instant case, the evidence adduced on behalf of the respondent shows that Din was heavily indebted and the respondent had filed a suit against him on the day of the execution of the deed of gift in favor of his son and that he had no property other than the one he had voluntarily conveyed to his son. The transferor undoubtedly had the intention of delaying or defeating the claim of his creditors. In order to save the conveyance from the liability of being avoided, it must be shown that a transferee had obtained the conveyance in good faith as well as for payment of consideration. In the present case, there is no valuable consideration. A gratuitous consideration such as natural love and affection is not a valuable consideration. A transfer in consideration of natural love and affection is not a transfer for consideration. In this connection, reference may usefully be made to the decision in Chidambaram, Chadia vs. Srinivasa, Sastraya, and others too, where it was remarked as, however, Mr. Krishnaswamy Lear, on behalf of the appellant, strongly contended that the last paragraph of Section 53 of the Transfer of Property Act, as interpreted by this Court in Ramasamy p. vs. Adinarayana p. 3, warrants a different view being taken. We shall briefly deal with his contention. In effect, his contention is that wherever there is any real consideration, however small, for the transfer, the question of intention is immaterial and the transaction must be held to be one entered in good faith and therefore not invalid as against creditors either under the statute 13 Elizabeth Clause 5 or under Section 53 of the Transfer of Property Act, even though it was in fact intended to delay or defeat creditors and had the intended effect. This contention is, we think, on the face of it, unsustainable for the simple reason that, under both enactments, good faith as well as consideration is made in terms an essential condition of the validity of the transfer. See also Suppelgua versus Das and another, for where was held that transfers founded on what is designated good or meritorious consideration, such as natural love and affection, while creating as they do a moral as distinguished from a legal obligation, do not count a transfer for consideration, but are looked upon as merely voluntary. Such voluntary transfers are not transferred in good faith and for value, to which the law extends protection. If fraud is meditated or if the necessary effect of those transfers is to perpetrate a fraud on third parties, it has been contended on behalf of the appellants that the gift was executed in lieu of inheritance, which should be regarded as valuable consideration. This contention cannot be accepted inasmuch as a deed of gift does not recite that conveyance was made in lieu of inheritance, and it is also extremely unlikely that Ubadin would convey his sole property to the first appellant alone as inheritance when he had another son called Kotanyo. Besides, the Exhibit C judgment passed in the claim case instituted by the first appellant, coupled with the address given by him in the trial court proceedings, clearly showed that the first appellant had been living in the house in dispute, where his father also resided. It is therefore obvious that the first appellant must have been aware of the litigation that had been going on between his father and the respondent, and the transaction of gift under these circumstances cannot be said to be bona fide. In the result, the appeal fails and is dismissed with costs, advocate fees, Jet 85.